Hello, good morning, and welcome to Newsfile. This is your most authoritative news analysis platform, and here on Newsfile, as always, we put Ghana first. As you have followed the news, the High Court, presided over by a Justice of the Court of Appeal with additional responsibilities in the Capital Bank matter, where William Ato Essien and others are being prosecuted over an amount that came out to be known to be 600 plus million, is rejecting a form of refund of a certain amount of a total of 90 million and appear to prefer to jail the one offering that amount. We'll get into the details of that story to discover and establish exactly how much is owed to the state by this accused person and whether or not the amount being offered is good. Then we will establish whether in fact the judge indicted the Attorney General as having been compromised in the matter. Organized labor is also rejecting 18% base pay. They are seeking 60%. They have raised that to 65%. Is that realistic in the present circumstances? The president has also been rejecting calls to downsize government. At the same time, he's raising taxes. How is that justifiable? I'm Samson Lardy Anyenini. We'll be right back to deal with the vexed matters. You're welcome back. This is Newsfile, it's your most authoritative news analysis platform, and here on Newsfile, as always, we put Ghana first. I'm your host, Samson Lardy Anyenini. Thanks to Evans Mensah for holding the fort so excellently in my absence. And this show is brought to you by Bank of Africa, strong as a group and close as a partner. MTN, everywhere you go. Star Assurance, your solid partner. Ashesi University, educating ethical and entrepreneurial leaders for Africa. Robert & Sons Optical Services, your comprehensive eye care service provider for 31 years. Duraplus, how you get your water matters. Remember, where Duraplus goes, water flows. St. Thomas Eye Hospital, providing excellence in eye care. Hoptel, everything you. Miway Insurance, dial star 165 hash on the MTN to join. And Magdan Aviation, your dependable private aviation request solved, just like that. And in just a minute, by way of my take, I'm only saying that we have a solid Black Stars. Disagree with me. I do not need to have the tactical and technical experience in football to know that this team that we gave not a dog's chance, this team that was even non-existent before the World Cup started, is a formidable one. I felt proud watching them take formidable teams elsewhere in the world in the manner they did. Even the very last game yesterday, I couldn't be proud watching them do what they did. Of course, they can do better. And I want to hope and pray that this country will not once again begin to dismantle this entire Black Star and begin an organization again that takes us without a clear, formidable, united team. These boys, I believe, are good. All we need, I suspect, is to keep them together from now on and ensure that what needs to be fixed is fixed. Enough of blaming them in a manner that we do, as though it is such an unforgivable sin or a sin in the first place to miss a penalty. The best of players all over the world, they do. So please, let's spare them. If we took our governments, if we took our political leaders, public office holders, if we took them on and held them to account the way we do the Black Stars, this country will be far better than it is today. We have done enough damaging their spirit. It is time to encourage them and get them together between now and the next time. That is my take. The Black Stars is a solid, proud team. They need to be encouraged. We'll be right back. You're welcome back. This is Newsfile. It's your most authoritative news analysis platform, and here on Newsfile, we put Ghana first. Let's begin by taking a quick trip to the High Court premises to learn what happened on Thursday in the case of the Republic versus William Atu-Essien, Tetenete Fitzgerald Odonko, and Kate Korte Papafio. Of course, she was discharged, acquitted and discharged upon a submission of no case. And so it is the three that are now remaining: William Atu-Essien, Tetenete, and Reverend Fitzgerald Odonko. Let's go to the court premises.
The right of the judge to either accept or reject. We're looking at section 35, even the parties agree, it's subject to satisfaction of the court. And the judge's wisdom has realized that there's a need to look at one or two issues. So you see nothing wrong with the judge trying to assert his authority as judge in the case.
The judge basically said that this was a bad thing. Couldn't you have got this up the better?
Oh, it's a matter of negotiation. And you know, if you're looking at a case involving an accused person, and the person makes a proposal, we also look at the proposal, consider, because let's take it, if you take a matter to court, it doesn't mean automatically you're going to have whatever that you are supposed to have. You need to bargain. We came to 90 billion, but they just said if there's a need to up it or do something extra, we have no problem with it, because it's a duty of the judge to scrutinize agreements reached by parties.
So you're now going back to the negotiation team?
Yeah, we are looking at the ruling. Perhaps we go back or we leave it to the judge to decide.
The judge made a very profound statement that if we'd allowed him to have given his judgment, he would have probably convicted the accused person. He would have gotten whatever he wanted. Why didn't you go through that route, sir? I
think the judge's wisdom decided to adjourn. He made a proposal for the adjournment to the 8th. He later came to the 13th. So it's within his wisdom, because we never prayed for an adjournment. If after his ruling, could have said he was ready to deliver the judgment and could have taken it like that. But he said he wanted to adjourn for the parties to consider the agreement again. We are not in any way aggrieved by the ruling by the judge. But that's
in all this, the AG has been stating that he wants to ensure that money that the state owns gets it back. Is this all part of the plan?
Yes, in fact, that's the plan. Because you have instances where people have been convicted involving huge sums of money. They are sentenced, they go to prison, they say they have not recovered anything, they will lose. So at times, if you are bargaining, there's a possibility that you can recover something, you need to also take a step. I stated somewhere at the last month that in all this banking crisis, our idea is to prosecute and, if possible, recover. If there's a possibility of recovering, as in the instant case, if the judge agrees with us, then we have to go along that route.
The judge talked about timing, and we know that sometime within the trial, the accused person had indicated that he wanted to refund some amount of money. Why has it taken this long?
It is true. The accused started making the offers to the Attorney General's office long ago, but we were not comfortable or agreeable to the figures that he was proposing. So that's why it took him all this while up to the last point of the prosecution. And we never relented in our effort to prosecute the accused persons. Despite the overtures that the first accused person made to us, we continued to prosecute the case. We got to the end of the case. Then he brought in this last minute proposal, which we thought was quite reasonable, but of course, subject to satisfaction of the court. So the first accused especially, didn't start his negotiation yesterday. He's been coming and then going. But it's rather maybe to his benefit that the last proposal that he made, we accepted.
Should we expect a better deal on the 13th for you?
We are going to look at the figures again, then we look at the options again. Two things. Either we have a better one or we drop the whole thing for the judge to proceed with the matter and then we look at where the ask falls.
When you hear the judge in this case, whilst he slammed the prosecution for accepting this, say that it appears the state is compromised, that sounded to me very extraordinary. Do you agree with that view of the way the judge approached it and his pronouncements on this matter?
Oh, on the face of it, it's reasonable. It's reasonable to look at it from that angle, but it's also possible that perhaps the state just, weren't up to the task of negotiating well with Atuasia. So looking at it, it would appear that Mr. Atuasia would have to up his offer a lot more, significantly, or like we say in Ghanaian English, gargantuan. He has to make his offer really gargantuan so that the judge will find it very difficult to reject things. And that would help because, as I said, we don't benefit that much from an accused person going to custody, or going to jail, especially where there's not a violent offense. It's a white-collar crime. And usually around the world, white-collar crimes, the option to do restitution and to avoid a jail sentence is quite common. You see, we have even also repeated it in the Office of Special Prosecutor Act. So it's in there where people can negotiate. So it's a good thing, okay? It's a good thing. It makes our criminal justice system better, more modern, more rehabilitative, give the person another chance, right? Yes. So it's good.
So the first voice you heard was that of Alfred Tia Yeboah, Deputy Attorney General and Deputy Minister of Justice. He was in the charge, so to speak, in the process in court. And the second voice you heard belongs to Martin Pebu, the venerable Martin Pebu. The lawyer who is very passionate, and many citizens have come to love him for being blunt speaking and not acting cowardly in the circumstances that we find ourselves. Now, let me introduce our guests for this morning, and we begin with the matter of the Capital Bank and the developments in the court. Alfred Tia Yeboah, Deputy Attorney General and Deputy Minister for Justice, joins us via phone. Kofi Bento, lawyer and Senior Vice President, Imani Africa, joins us via Zoom. Dr. Kwabena Nyako Otu, Chief Economist and Director, Labor Research and Policy Institute, Trades Union Congress, TUC, also joins us via Zoom. And here in the studio with me is Beatrice Annan, member, Legal and Communications Team, member of the National Democratic Congress. Thank you, lady and gentlemen, for joining us on Newsfile this morning.
Thank you, Samson.
Thank you, Samson. Great.
Thank you.
Right. So, Alfred, let's begin with you. People have been very angry at the Attorney General. What you and the accused appear to have agreed on. We don't know the full facts. All we know is that you have allowed the accused to pay 30 million and he's to pay subsequently another 60 million, making 90 million in total, and then invoking Section 35 of the Courts Act. So he will plead guilty and then he'll be convicted, but he doesn't get to go to jail. And it is reported in the media widely that the judge suggested that you guys have been compromised. We'll try and set that record to correct, because that is incorrect for those who have the privilege of knowing exactly what the judge said. So to begin with, many are full of praises for this judge for being the one who is, as it were, keeping the gate and watching the public purse, and you that is supposed to lead this for us are disappointing us. So for starters, what do you have to say?
Thank you very much, Samson. As a start, I would like to place it on record that the Attorney General's office, and for that matter, the Ministry of Justice, has never been compromised in this matter, will never be compromised in this matter, and is not prepared to be compromised in any other way. That thing should be set straight. This particular matter, as we all know, has been pending in court since 2019. The accused persons originally were 4. At the close of the defense case, the 4th accused person was acquitted and discharged by the court upon submission of no case. So we are now left with 3. Out of the 3, Mr. Atwesian, who happens to be the first accused person, has been charged with 3 main offenses: conspiracy to steal, stealing, and money laundering. The second accused person has also been charged with conspiracy with Atwesian, as well as stealing substantive offenses. The third accused person with abetment of crime. The total amount involved in the whole case is 192 million Ghana cedis. 192. In the course of investigations, it came out that an amount of over 100 million cedis had actually gone back to Capital Bank. So that amount, from our point of view, is still with Capital Bank, leaving 92 million. Then in the course of investigation, once again, the first accused person made a refund to Iyoko for 1.34 million Ghana cedis. So if you net everything, the amount left is about 90 million plus, 90 million Ghana cedis. Let's also not forget that for all the negotiations we've had with Mr. Atwesian, it didn't start last week. 2021, his lawyers, relying on Section 35, made an offer to the Republic. And they indicated in their letters to us that Atwesian had made only 27.5 million Ghana as the amount of money that he thinks it could be made to refund. 27 million Ghana cedis. We met and said, no, we disagree with you. We had a series of letters to that effect. And at the last time that we even had, because they still insisted, they moved forward and said, let us go to 57.5 million Ghana cedis, and said that was the only thing that he concedes or agrees that he needs to refund. We rejected it. Then he later on went on to add that he was prepared to top it up by way of compensation to make it 70 million Ghana cedis. That one too, rejected it. Then the last offer they made was that, fine, since we're insisting on rejecting whatever until we go to the 90 million, they said, fine, we're going to pay the 90 million. They said, fine, if you've gotten that way, after all, under Section 35, it is permissible. But the moment the state agrees with an accused person, it's not final. The judge who is sitting on the matter has the power under Section 35(4) to either reject, modify, or endorse it. So we were clear in our mind that our agreement with the first accused person wasn't final. It was subject to the satisfaction of the judge. And Section 35, I've heard this argument that it's not applicable. No respect. The very judge who is sitting on the matter has stated in court many times that he, as a judge, since Section 35 is available to the accused person anytime that accused person, first accused person, was ready, he could be informed as the judge, even at the last minute. So we also labored under that impression. But if the accused person was ready to come up with that sum, then perhaps we also need to look at it. In any event, Samson, you know how the litigation goes. If you take your matter to court as a prosecutor, or even in civil matters, you can never determine the outcome of such a case. So that's why, even have, at the point in time, you need to negotiate. It's possible even go your way, it may also not go your way. In negotiations or in bargaining, you need to look at how you can go, where you can go, and the point that you can go. So in our wisdom, that small wisdom that we had, realize that, fine, it will be in the interest of the state to get money from an accused person, rather than saying that an accused person should go to jail and we don't recover anything. I can cite various instances in this country where people in high places have been convicted, sentenced to prison terms, and the state could not recover even one Ghana cedi. So insofar as we have the Cost Act that was enacted in 1993, way back with the amendment, and in the wisdom of Parliament, they've made a provision for that kind of opportunity to be available to an accused. As prosecutors, we were not ready to also just close our eyes to such a provision. So that's how come we got to where we are today.
Okay.
Whatever we've done is subject to the satisfaction of the judge, which we still think he has the power to either amend or reject.
Okay. We'll get to why your preoccupation, as you say, or your primary interest is in recovery of money rather than wanting someone to be jailed. That is, if you succeed in getting them jailed and not getting any money from it. And you say there have been many cases. Of course, Ghanaians are aware of the very, very many cases, including, of course, the Woyome matter, which you still are struggling and can't get even a quarter of that money back to the state. We are aware of the judgment of this same court on the 12th day of May 2020 in respect of the Republic versus Eugene Bafuboni, Matthew William Tevi, Dr. Owusu Ensah, Alhaji Salifu, Mimina Osman, and George Derek Opong, in which, in the end, 3 of them were convicted. I think 6 years. One was for 5 years or so. In respect of the NCA matter, in excess of $4 million US. As we know, you guys have not reported to us that you have recovered any money. Whilst that is important, that we appreciate that you want to take money for the state, the judge made a statement that your conduct smacks of or seeks to be something that will make crime attractive to people. Doesn't that suggest to you that it appears that you were making success from the judge's comments, that you would have gotten jail terms for the people involved, you would have been successful? So maybe there's no need to be rushing to want to settle matters. And the bottom line for the judge was that you are seeking to encourage or make crime attractive.
Yes, Samson. The judge spoke from an advantage position. He's the one presiding, and he knows what he may want to do. But as prosecutors, we cannot be certain that we will win our case. That one, we may go to court. It may go the other way. But perhaps the judge passed that on because he's sitting in a privileged position. So that's the response I'll give to that. But in any event...
Mr. Shuaibua, you cannot be certain that you will win your case. But at the Attorney Generals, as prosecutors, as we know from some prosecutors, unless they are sure of about, say, 80% success, they don't go to court. So you must have some conviction that you have a good case. That's why you go to court. Is that not?
Yes, we have a very good case. That's why we are in court. That's why we call 17 witnesses. But at the end of the day, this is the duty of the judge to either uphold whatever we presented or dismiss it. So far as we cannot deliver judgment in that matter, we cannot be certain someone wants to deliver judgment. We have done our part. Now this business or this issue about making crime attractive or something, if someone is convicted for stealing, money laundering, you know the legal effect, you know the implications, you know the limitations placed on such people, because those offenses border on dishonesty. And if you take our constitution, there are clear provisions on how people have this kind of limitations because of their conviction on offense involving dishonesty. If we move further, if you take the Companies Act, there are elaborate provisions on limitations placed on people who have been convicted for offense involving dishonesty. You take the Act 930, the banks and financial specialized institutions, you have provisions there. So apart from the person going to prison, which is something that is also not ruled out, there are other serious limitations on people who are convicted.
Educate my audience a bit. What are these limitations you are talking about because of a conviction? And in which matter, what you are saying essentially is that using Section 35 of the Courts Act to settle the case doesn't mean that there will not be a conviction. There will be a conviction, and therefore, Mr. William Atu-Essien will still suffer the consequences of a conviction. What are these consequences that you are talking about?
Yes, Samson. First one, let's go to our Constitution. If you want to hold any public office, if you want to be an MP, if you want to be a minister, a deputy minister, if you have been convicted of an offense involving dishonesty, you are limited from holding such positions. Now, even if you want to be a chief, if you're a lawyer and you want to be a chief and you be convicted for an offense bordering on dishonesty, you cannot.
In fact, you can't be a lawyer. If you're a lawyer, you lose your license.
That is it. If you're a business person like Atu-Essien, who is into finances, from the Banks and Specialized Deposit-Taking Institutions Act at 930, you cannot be a director of any financial institution or work in any position relating to finances of a company. You cannot. You are barred. If you go to a Companies Act, you cannot be a director. And so these limitations are there that if you think that you've been convicted, oh, it's stealing, so you're going to sleep, you've paid, and that is it. I tell you, even if you are traveling out of state and you have a conviction of more law, a very serious offense, I tell you, there's a place that you go and nobody will even be ready to listen to you or even deal with you.
All right.
So there are serious limitations.
Right. We'll get to the details as to the figures because the public is aware that the Bank of Ghana gave liquidity support of 620 million. People want to appreciate exactly why we have come to. Is that not that amount for which you are prosecuting these people, and why is 90 million sufficient? You have attempted to explain, but we'll go into details about that. What the public is also asking is, you can have the two. You can have the person convicted, sent to jail, and still get your money back. So you can have, all that. Why are you not interested in that? If the person is going to be convicted for stealing, by our law, and per that particular section that you are charging the person on, section 124, it will not be, a maximum of 10 years. It will rather be for 25 years, correct?
Yes.
Right. And then for money laundering, according to the law, you are supposed to be liable to a fine not less than 100% and not more than 500% of the proceeds of money laundering in the case of an individual. And then a term of imprisonment of not less than 12 months and not more than 10 years. Both the fine and the term of imprisonment, or a fine of not less than 300% of the proceeds of money laundering in the case of a corporate entity. So the public is saying you can have both. You can get your money and send the people to jail at the same time. Why do you want to take the money, give them a conviction, they suffer all the limitations you talk about, and then they don't go to jail?
Samson, it is true that you can get a conviction and also have some recoveries. But that will depend on whether the accused person has property that you can fall on. Usually, I don't like citing matters, but since it's a public, the Wyoming matter, 2011 to date, how much has the state been able to recover in that particular matter?
Of the 51 million?
Exactly. you want to trace and get properties of people that you may want to have so that you can go through legal process, auction and get money, and you are not getting it. So the possibility
how much did he pay? How much did he pay himself? I think some 4 million, and then later you got some properties at this popular place, and Trasaco, and those properties they don't give you so much to cover the 51 million.
Not even up to 20%.
Not 20%.
Yes, not even up to 20 or 30% if my figures are right. And so that money is outstanding because, and per our laws, if someone doesn't have the asset that you can fall on, you cannot say you're going to prison the person. So in this particular matter, maybe they are convicted by the court, which we are certain the court may do, since we have a very good case. That is how I want to state it. If they are convicted and Atuesian is imprisoned, and the court says we should go and then go get his property and then auction. So that's the next hurdle. Do we know his property? Properties does he have? And if you identify, will someone not come in and say, oh, this property is mine? And how long will it even take us to go through that process? So that process, if you have the property there, that will be the thing that as a prosecutor we may want to follow. But if you don't have it there and then you go along that line, the person will go to prison, the money. And some people may also, I'm not saying that this instant case, they may still acquire property in the names of others.
That failure or difficulty, don't you take part of the blame? Because since 2015, any wise person who knows that he's a candidate for trial over this bank collapse issues, 2015, 2016, until 2017 that you put him before court or so, I think it will be such a lousy lawyer or a lawyer who doesn't know what he's doing that will not advise the client to do the right things. May not even be a lawyer. It will take the person himself deciding to conceal his properties, put properties in the names of other people, among others, so that you can't find them if eventually he's convicted. So are you not partly to blame for not ensuring that at the beginning you were proactive enough to take control of these properties?
The matter was investigated by Iyoko. And Iyoko, through the investigations, did what was expected of them. As I speak now, I don't have any to the fact that property A, B, or C belongs to Atuesian, unless, of course, I fall on Iyoko. But what I can say is that if we go by the suggestion of the public or some of the members of the public, that we go for conviction and recovery, we have no problem. But the issue is whether we can get some property and then get the money for the state.
He had, we understood, he had about 19 new vehicles that he was taking charge of from the port, that had arrived at the port. You confiscated them. It's the same way you must find his properties so that he goes to jail and suffers, his properties also suffer. Is that not what you should be doing?
Samson, that is what is the ideal situation which we'll be happy to do if we know the property. If the public can come out, perhaps we know A, B, C, D, and we can praise. We will even drop this kind of plea again. Sorry, we will even drop this issue about going under 35. We may say, fine, we are not bothered. Let's go to the trial. When we get judgment and the court orders, we'll take it.
Okay. Now to this issue about the figures. Yes, about the figures. You have informed us, and for those journalists who have followed this story, they have known that this is not the first time. So it is not exactly a surprise on the court that he sought to come under Section 35. And that this has been the manner in which he has sought to proceed. And I have some of the records of the court here. From the 21st of May, 2020, before the court actually granted you the permission to try to use Section 35 to see if you can settle the case. And then on the 18th day of June 2020, the court again granted further permission. On the 18th of June, the court said, I accede to the prayer of both the prosecution and defense counsel for one last adjournment to enable them conclude the negotiations under Section 35 of the Courts Act, Act 459. I place on record that, notwithstanding any possible outcome of the negotiations, trial will proceed on the next adjourned date, adjourned to 9th July 2020 at 11 a.m. Then subsequently, on the 4th day of November 2021, on the record of the court, there is also the court saying, and I quote, by court, I have listened to the learned chief state attorney and have attended to the submissions and prayer of learned counsel for first accused, that's William Atuasian. I have noted the attempt underway by the first accused to take advantage of Section 35 of the Courts Act, 1993, Act 459. I have noted in particular the prayer for first accused to be afforded more time to conclude negotiations and a further date for him to open his defense. The court has not hesitation at all in granting the prayer for more time for the parties to continue their negotiation, but the court is unable to accede to the prayer to defer the opening of the defense of the first accused for a number of reasons, and the court gave those reasons. So at least for 3 times, the court was aware that there were attempts to settle from May 2020 up till November 2021. But don't you think the court is still justified that on the day that it is going to deliver its judgment, you guys spring a surprise on the court that it should use this process rather than give its judgment?
The court was right in the sentiment that it expressed with regard to the timing. But we need to let the court know where we got into. That's why in all these transactions, it is not final. It is subject to the satisfaction of the judge or the court. So if the court, in its opinion, it thinks that, fine, this matter is not a matter that will go unaccepted because of time, we have no problem with it, because we cannot impose our agreement on the court. But people who are patronized services of the court and who are also partakers in the law of justice, we must not hide information from the court. We need to let the court know this is where we got into and whether the court agrees or disagrees. So the timing is something that the court may want to say because of where we got into it, they want to deliver a judgment. We will not have any problem at all, because we have called 17 witnesses. They have closed their defense. It's left to the judge to deliver his judgment.
But like a plea bargaining process, you are entitled to come to this kind of conclusion any time before judgment. Is that not so?
Exactly, Samson.
So,
and that's why that was what was done in this particular case, before judgment. After judgment, you cannot do it. Before judgment, it can be done.
So what do you make of the court's surprise attitude, and also the court's suggestion that what you are trying to do is actually Section 35 doesn't afford you a settlement in this regard because the loss, so to speak, is not economic loss to the states?
We disagree with the judge on his interpretation of Section 35 with regard to the facts in this particular matter. Now, the money we're talking about, the 192, belongs to Capital Bank. We agree. Where is Capital Bank now? If Samson will help me. Is Capital Bank still in existence? No. The assets of Capital Bank have been taken over by the government via Bank of Ghana. So if we're talking about who owns the property of Capital Bank, it is the bank, it is the government of Ghana. So that loss that we are talking about, the ultimate sufferer is the bank, is the government of Ghana. So we disagree that the money does not belong to the government of Ghana, but rather the shareholders of Capital Bank, because Capital Bank is no longer in existence.
I have followed this case and with great interest, of course, also because, and I'll make this disclosure, I'm just moderating. The disclosure is that, for those who don't know, it's already public that my firm are lawyers for William Atu Essien in the civil case, not the criminal case. We are not in there. That's Thaddeus Osori and his firm. Now, the question I'm asking you now has to do with in the submission of no case. In fact, when I think Dominic Ayine, K.T. Hammond, and others appeared before the court, I think their first comments to the court was that, how can I steal my own property? And in the submission of no case, they make that point, and the judge rejected it that the money belongs to them. It doesn't belong to them, it belongs to the state instead. So how do you reconcile that now that the judge suggests that the money is not the state money, but it belongs to the shareholders? Does it appear that the defense is being armed against the state?
And that's the reason why we disagree with the judge on that. The money we are talking about now belongs to the state. In any event, if you talk about someone being the owner and cannot steal his own property, as well as stated, that one, any court will reject it. Because if you talk about company, you may be 100% shareholder. But if you take money from that company without the consent of the board of directors, you've stolen the money.
Okay.
Even though you're 100% shareholder.
My last question to you before I go to my other guest and come to you finally as to your next line of action on the 13th of December is, what are you in court prosecuting Atu Essien and the others for? How much money is at stake? Is it not?
Yes.
Is it not 620 million Ghana cedis being the liquidity support that was given to the bank that led to this suit?
We are in court prosecuting Atu Essien and others with respect to an amount that the Bank of Ghana gave to Capital Bank as liquidity support. And that amount was 620 million. Out of that amount, 192 million Ghana cedis, from our point of view, was stolen by the accused person, the first accused person. So the amount the Bank of Ghana gave them was 620. The win amount is with Capital Bank, for that matter, with the government, because we are now running that bank as a civil entity and another institution. What is now in contention is the 192 million Ghana cedis, but not the 620. But the 620 went, but only 192 was taken by the first accused and the others without a consent.
So how do you accept 90 million? And the judge was very angry about that. How do you accept 90 million as a refund for 122 million?
It's not 122 million.
92 million, yeah.
The 192, as I said, 65 million cedis. As a fact, we realized that after the auditing, that money was with Capital Bank because there was a company that sought to buy shares in Capital Bank with 65 million Ghana cedis. That company, upon realized that company also belonged to the same Atu Essien. So Capital Bank took that money and said, we're not going to give you any shares. So that money is with Capital Bank. There was another 35 million Ghana cedis to also acquire shares through the company. We lifted and realized that that company was also owned by the first accused. We said, fine, that one too, this money you paid, so you're not going to get any shares. So 100 million out of 192 just came. Thereafter, through investigations at the Atu Essien also refunded 1.3 million Ghana cedis. So the amount is not 192 now, it's at 90 plus.
You said 65 million. 65.
Yeah.
Can now be traced as money that is still within the state.
Yes.
Then 35 million also can be traced in the same manner.
Exactly.
But he paid 1.3 million.
Yes.
That gives us a total of how much?
I think that's about 101 plus, or 101 plus, but if you add it, you got 100 million to this plus 1.3, so about 101.3, yes.
Okay.
Yeah.
Okay. So as far as you are concerned, how much is the amount left?
The amount left now, after the payment, is 90 plus million Ghana cedis.
90
that's
plus.
The amount. Yes, that's the amount left.
So the judge is...
We are still charging, or we charge him with the 100 million, that the amount that he refunded, because he stole it before returning it. So that will not absolve him.
Okay.
Yes.
So the judge is still justified that in 2015, 2016, you don't come to 2020 to seek to refund that amount without interest and without some compensation to the state.
The judge may be right in his conclusion on that. But the question, as I indicated earlier on, Atuisen has never admitted stealing 90 million Ghana cedis. He has always maintained 27.5 million Ghana cedis.
Okay.
They later moved to 50.7. So from their point of view, they have never stolen 90. But they decided that they were going to pay something to top it up to 70 million. We rejected it. Then later they said, we will have to go to 90. They said, fine, getting to 90 is quite reasonable from our view. So let's accept it and see whether the court will also satisfy with it.
Right. So eventually, what the accused admits is 27.5 million.
Yes.
Which is what he calls the promotion.
Promotion, yes.
The money that he felt that he was entitled.
Yes.
So he says, this is all I owe. So first, that is what he sought to pay to the state, and you rejected his offer of settlement.
Exactly.
And then later, they managed to push it up to 57. And you rejected that too.
Exactly.
And now they have pushed it up to 90, and you feel that is good.
Yes, Samson.
Okay. Let's hold it on there, and then we'll return to you finally. But the issue of compromise. You were sitting in the court. I came in there. By the time I got there, everything was almost done. He was rounding up. Did he say that the Attorney General was compromised in this matter?
I never heard a judge use the word compromise. No. I don't think the judge would have even said so. No. In terms of he saying that we were compromised. Maybe,
I think he used the word compromise, but not to you, the Attorney General. That what you were doing would compromise the consequence for the other two.
Exactly. With respect to the other two accused persons, A2 and A3. Because remember, A1 has been charged with conspiracy that he conspired with Atuisen. So if Atuisen is pleading guilty to a charge of conspiracy, what happens to that person? Because conspiracy is to be two or more.
All right.
And you can't agree with yourself. You must agree with someone. So is it the fact that he agreed with the second accused person automatically? I think that's the question that was being raised. But in any case, as a legal principle, if you plead guilty to a charge, it's not binding on the other accused person. That is it. And then there's an aspect of abatement, that someone abated Atuisen, the third accused person. So in the case the Atuisen pleads guilty, does it mean that the accused person automatically also abated him? These are legal issues that will have to be unraveled in the judge's judgment with respect to A2, A3, if we agree under Section 35. So the word compromise, as to whether agency officers be compromised. Some of us are in public office to serve our nation, to stick to the rules that we are supposed to follow, and we are not prepared.
All right.
If you point guns at us to compromise our position.
But don't you take the concern of the judge that if you settle with the first accused, who is facing the substantive, charges of stealing, money laundering, and all of that, if you take that and the rest of them are merely, quote unquote, I say merely, the consequence is heavy. Because even if you are an abettor, you will suffer the ultimate sanction. So if, you are settling with the first accused and the second and third only have charges that are supposed to be just that they abetted the process, aided and abetted the process, don't you see that you are compromising their situation? Is that not a concern that you should take note of? So that the main person will not go to jail, but the other persons who were just aiding and abetting, so to speak, I say just again, if they are found guilty, they go to jail.
Now, Samson, if you look at the charge sheet, the other two accused persons, A2 and A3, especially A2, apart from conspiracy, is also being charged with stealing. So if the 19 we're talking about, part of it, A2 has been charged with it, with stealing. It's only the third accused person who has been charged with abatement.
That's Fitzgerald. Is it Fitzgerald Odonko?
Yes.
Okay.
That's when it's stated. If you are convicted for abatement, you may be punished as if you were the very person who committed that offense.
That's right.
So if the first accused thinks that fine, I'm guilty, and because I don't want to go to jail, I want to take advantage of this, and he doesn't go to jail, and you think that you are not guilty, but the court comes to a conclusion that you are guilty.
In fact, by our law, even if the offense was not completed, you will still suffer as an abettor, right?
Exactly.
As a conspirator.
Yes, but you cannot force an accused person to take advantage of Section 35 because he believes in his case.
Okay.
That's the reason why A1 has been coming. I mean, if I will deal with you, but A2 and A3,
all right,
we don't have to worry them at all.
Okay, thank you very much. Please hold on. Let me go around and get to my other guests. Then I wanted the Attorney General themselves, who are, in the center of all of this, to try and help us in a better way before every other person will come in. I just hope I succeeded in doing a bit of that to assist my other guests. But we have also seen documentation that suggests that the Attorney General, the first accused, William Atuesian, for all the time was admitting to only 27.5 million as money that he was ready to give back, because that was related to business promotion payments to him. And that takes care of counts 13 to 23. Remember, the counts end at 23. And then there was the other two from counts 1 to 13. So he seems to cover everything. Then the Attorney General has been objecting to this completely. So eventually, what he has actually admitted to is 57.5 million that he agrees to pay. So by his letters we are seeing from his lawyers, it does appear that the Attorney General rather may have done a good job by getting up to 90 million, but not exactly that. It is 90 million that is in fact owed, and they are paying 90 million without interest and without reparation or restitution. Because the record also, according to the lawyers for the accused person, show clearly that what in fact is owed is that amount, nothing more. So if they are paying 90 million, it is not a fact that they are admitting to owing 90 million. Now, let me go to Kofi Bento. Kofi, thank you very much for joining us. I don't know where you take it from.
Well, Samson, good morning and thank you. It's interesting, but it's also very serious. I take it really from the judge's pronouncements. And as a lawyer, you and I know that a judge must be so restrained that you cannot read his mind except through his judgments. And difficult as it is, that is what they are trained to do. And I have to say, most of our judges really do well at that. You think you're winning, you lose. You think you're losing, you win. Even when they are reading the judgment, you can't tell exactly where they are leaning. So it's interesting that we heard so much from this judge at this stage. And let's be clear, again, you and I are lawyers, this matter is still with the courts. So we are not debating the merits of it. We are just looking at the general issues.
We are discussing the outcome of Thursday.
Yes, but I'm saying it's still in the court. So I just want to let the public know that we are not prejudging the matter.
Exactly.
And we are being careful not to go into the merits of it, just to set that aside. Now, let's be also clear. The judge was right and within his powers to accept or reject the deal that the AG made, and was right, okay, to give, some sort of, reason for it. But I do think that in making the statements that he made, he opened too many doors. He opened too many doors. First, we need to know that Section 35, which is what the AG was relying on, it was started in the judge's courts. Those of us who know about this case know that he basically opened the door and said, you can look at that. And let's make this caveat also. People are emotional about this matter, and they know nothing about the details. Nothing. Some of us have taken time to go into the details. It's a bad case, but please, if you don't know too much about the details, hold your peace. I'm saying this because it is the lawyers in court before the judge who will go through the numbers. Samson, I know you have some numbers. I also have some numbers.
Yes.
What is Atuese admitting to? How much has been missing? How much has been recovered? What is left? And all those things. So the details people can't understand, and we should all reserve passing comment on this or that. So back to the issue. Look, as it were, the AG went in squarely within the law to try and gain something for the state. Now, we need to know, I have seen people who were willing to go to jail, come back, and come and enjoy their money. I don't want to tell you a story about somebody who kept us 2 hours in the Forex Bureau after they had come from church changing money. So there is good merit to this Article 35, Section 35, and I think that I trust the AG's department. So it was sad to, hear suggestions that somebody has been compromised or whatever it is. Let's, leave that. And let's leave them to do the work in court. And then let me make this point also that, look, I feel a bit worried about the approach in terms of the statements made, because I think it revealed too much of the judge's emotion and where he was going. And to everything that was said, I think there are sufficient legal and jurisprudential arguments against those positions, which I believe Mr. Esien's lawyers are well capable of and they can make. So I'm making general statements to the effect that many people are emotional about this matter. This is one of the matters where I would trust the AG and the people there, some of who I know and I trust, to do a good job. And until we get all the details, we should be restrained. And for whatever it's worth also, I think that nobody should really be taking certain stances publicly, as it were. Let's let this process run its course. But as far as I am concerned, I think it is proper that we give place to Section 35. Too many people have stolen money from this state and have been willing to go to jail for 5 years, come back and enjoy it. If we can get something back, and you know the litany of cases, we don't have time, so I don't want to go into them, where people go free and nothing happens. And even cases, you just cited some, Woyome, the Dugu cases, and we don't recover anything. So for me, if there is a chance to recover some money, and like you said, you can actually recover money and also convict the person, and the person can actually also go to jail. So we should not get this view that somebody is going to cut a deal to let somebody, run free, and that this is a bad situation. It is not. The details are what are in court, and they will have a chance to also make those arguments again before the judge. So for whatever it's worth, I think all of us, including my lord, the judge, let's see how this pans out ultimately. But people must know clearly that 35 is in the law.
Yeah, so Kofi, you and I are privy to some bit of the documentation. Now, in court, it is, as it were, shown without any question that there was a repayment through an EcoBank check with a specific date of 65 million. There was another repayment via EcoBank check, that's the tranche 2 payment of 35 million. And then the money that Essien paid to Iyoko also is not in doubt, 1.3 million. And then there is a 30 million amount that is supposed to be held by the receivers for the sovereign bank. You remember the money that was, out of the liquidity fund that was used to set up another bank. Yeah. So as far as, the first accused is concerned, what they in fact owe, actually is 26.2 million. Attorney General may have done a good job by getting up to 90 million, rejecting just paying the 27, which was 26 million, rejecting 57 million, and eventually getting 90 million. But Kofi, the judges concerned, many Ghanaians are concerned. You don't have to make crime attractive. That you take money, you refund it, you don't go to jail. You may have even made profit out of it.
Samson, I agree with you. But again, like I'm saying, there are many arguments against the sentiment that has been thrown out. One of the arguments is in the numbers. And those of us who have seen the numbers know that indeed the deal that has been struck by the AG may be a very good deal. But again, I don't want to go into the merits of the matter, partly because it is sub judice. Number two, there is so much emotion around this matter that anything you say that sounds like it's going to be in somebody's favor will make somebody think you have been compromised or I have been compromised. And so we should leave them to do the numbers in court, okay? What we must know is that there is very good reason in philosophy, in jurisprudence, in what is proper and practical for us to have a Section 35. And I repeat, because there are people who actually still stake money and want to go to jail for 5, even 10 years, come back and enjoy it.
In that regard, you are disagreeing. In that regard, you are disagreeing with the judge that 35 is not applicable in this matter. Again,
I have many arguments on that. I don't want to make those arguments here. Let me just say, yes, I disagree with him. Because 35 is a very good provision, and those of us who are in policy, who look at what goes on in this country and the millions that we lose and we don't recover, you see, over the decades, over the years, people have come to realize that, indeed, without 35, it is lucrative rather to steal. So indeed, the argument is counterproductive, you know, against what was said. Okay. That, oh, because of 35, people are going to steal. It is without 35 that people steal. And we've seen some, I've seen some. I don't want to go into the details. The point here is that with 35, you know that if you steal, you can be asked to cough up the money. And in this particular case, if you go through the numbers, what is being coughed up is quite substantial given what is being admitted. Okay? And so going to jail will not let you off to go and enjoy the loot. But again, I'm so restrained.
The judge's argument here is that the money belongs to the shareholders. It doesn't belong to the state. Even though we have heard the lawyers from the start argue that liquidity support is in fact loan, and that loan is payable, so it's not state money, so to speak. What do you make of how the judge wants to look at it now? It doesn't matter that from the onset, the judge was amenable to them using Section 35. But where it has gotten to, he's entitled to have a change of mind. And he is a final approval of what is agreed.
Samson, you are leading me into temptation. There are very sound arguments against that proposition. I will restrain myself and simply say this. If the state has gone through a process of cleaning up the financial sector and cost us money as taxpayers, the money that can be recovered can be argued to be money for the state. But again, I don't want to go into the merits of the matter. I believe the lawyers involved are very competent. So what we all should say, we should stay on the policy issues, that the judge is right to voice those concerns. In fact, that is what the average person has in mind. But judges, lawyers who have details and also have the benefit of understanding the law must actually help the public and move us more from the emotion into the facts by restraining ourselves and dealing with the details in court. Now, after the judgments have been given, we can take our time to explain why this happened the way it happened.
Well, judgment giving. Judgment presently is being arrested, so to speak, in respect of the first accused.
Well, I still want to respect the fact that it is not over. Okay. But I just want to say, for whatever is worth to the public, that this is one of the cases where I think our state officials are doing a good job.
Okay, thank you.
Look, over 10 witnesses were called. The detail we are going through. You can't just get up and then, throw somebody in jail because you believe he has done this or that. And then when you go into the facts of this matter, There are people who other people think should have been also, prosecuted. No. If you know the past, you know that no.
Yeah.
So let's sometimes you have to trust the people who we have elected to do the job. And in this matter, really, I will say that I trust what the Aegis department is doing.
Okay, thank you very much. And Kofi says people also believe that there are people who ought to be standing trial who are not standing trial. And top on that list that has always come up has been the chairman at the time of the Capital Bank. That is Dr. Mensah Otabil. What people forget, and that's the aspect that my firm is involved in, is that there is a civil matter also pending. And Otabil and associates, ICGC, is it Otabil himself, are all in the civil matter to recover specific amounts that the state, the receiver, deems they to be owing and they ought to pay. So that one too is going on there. That one actually has about 18 different defendants, including Atu Asian, who is the first defendant. Yes, Beatrice Annan.
Thank you very much, Samson. I've listened to the discussion and I've listened to the Deputy Attorney General, but on this matter is the duplicity and the complicity of the Office of the Attorney General that I want to talk about. And listening even to him more, for me, I think more investigations should be undertaken. Why do I say this? I believe that the prosecution of Atu Asian A1 and the others in the instant manner is just a face-saving gimmick to rationalize why the government had to use 25 billion to clean up a sector that we are told needed 9 billion to clean up. And so, some way, somehow, signals have to be sent to the people that we are not wrong, albeit I believe that they are. Why do I say this? If the government believed that these persons have indeed caused them to use in excess of 25 billion to clean a sector, what will the recovery of a 90 million out of it do? Now, the question is that I have heard you
say... That's a total of how many banks? This is just one of the banks.
Yes, that's a total of... So I will be doing the average.
Okay.
Now, I've heard you say that in that case, the first accused only admitted to about 57.5 million. Now, listening to the Deputy Attorney General, I'm even more worried because in his submission, or the case of the prosecution is that 620 million were advanced to Capital Bank by way of liquidity support, out of which 192 is
what they are pursuing.
He does not tell us why the 90 million. He tells us that some way, somehow, 65 million cedis were found to be within or still with the state. And he made a statement, I hope it's a slip, that 35 million belonged to a company where the first accused is a shareholder. I hope that statement was a slip. Because if these are the facts, and the Attorney General's own admission is that 90.66 million is what is outstanding, then the question then becomes, what was the basis for the state accepting the 90 million? Because I have been an advocate of non-custodial sentence. I have written copiously on non-custodial sentence. But we have to know why the Attorney General is settling for 90 million when in his own admission, given the figures, it is 90.66 million that is in contention.
Okay, let me read a portion of what is supposed to be confidential that we have been privy to, which Kofi Bento was referring to, which ended up in the settlement. They actually brought in accountants to do whatever reconciliations had to be done against the investigation that had been done to bring up the amount to 192 million. And this is what the lawyers for Atu Asian contended. And I believe eventually what the AG admits. It says the sums of 65 million and 35 million are the subject of counts 1 to 4, 9 to 11, preferred against Mr. Essien. In respect of the aforesaid sums, 35 million and 65 million, our client has testified and proved that the aforesaid sums of money remained in the balance sheets of the capital banks as deposits against shares until the receiver was appointed. So I refer to you 2 checks paid to through EcoBank,
yes,
where these monies sit there.
Yes.
It says, with regards to the 35 million in particular, we must add that the aforesaid sum forms part of the 100 million, which are the subjects of count 1 to 4, with the effect that making the same sum, 35 million, the subject of counts 9 to 11, also carries with it the danger of double jeopardy. I suppose you will understand this.
So, yes,
and then they say, in any event, payment of the 35 million is evidenced by Capital Africa Group check dated 27 January 2019, and they bring the number. Then the payment of the 65 million, they also give the check number and the date of 1st of February 2016 payments.
So by this, it means that the Attorney General has admitted that.
He said so.
Yes, that it was 57.5 million. That are the monies appropriated or allegedly misappropriated. That is it. So that brings me to my point that if you have 8 banks collapsed on the basis of some misappropriation, theft, and other corporate governance issues going on, and you said that you were cleaning it. Now we are now being told that the Attorney General's own admission says that the 65 and 35 can be found on the balance sheet. So
and then there was a 1.3 paid to Iyoko.
1.3 paid to Iyoko. So back and forth.
And then Iyoko has also seized 19
So
vehicles.
back and forth, the admitted figure is 57.5 million. My point, and I will not also talk about the case because I know judgment has not been given. As a lawyer, I'll refrain from going into the merits. My case is that looking at the banks which were collapsed, if in the case of Capital Bank, we are being told that it's 57.5 million. If you run the average, how much are we talking about? For which reason government was clothed with capacity to spend 25 billion cedis in trying to get these sectors back?
Okay.
That's
but you
my
also
main
appreciate
concern.
what the Attorney General speaks about, which I think Kofi had mentioned, about the fact that the state has taken over these entities.
Exactly.
Now, when it took them over, Capital Bank and UT Bank were handed to GCB Bank.
Yes.
So their assets, everything, remains with the state.
Yes.
You appreciate
Yes.
that?
And
so that is money.
So that's something I think you should get the point I'm making. The point I'm making is that...
No, your point of duplicity and complicity is what I need to appreciate.
Yes, so why I'm saying that is that you say that there is an issue. There was an audit by the Bank of Ghana that said that 9 billion could clear that issue. When you took over in 2017, you said that given the circumstances and the monies appropriated, 25 billion rather than 9 billion. My point is that from the accounting background, if you take the assets like they have taken over Capital Bank, Heritage Bank, and they've given to other banks, the difference will be that indeed some 25 billion cedis have been misappropriated, for which reason you use the same either by way of liquidity support or whatever. But if we are being told that from the trial, given instances and given back and forth, the state today is admitting that with Capital Bank alone, the money misappropriated is 57.5 million, then we have to raise very serious questions.
All right. So what's your point? Should the state be pursuing Section 35 or they shouldn't?
Well, the state should be pursuing Section 35. But my question is that, what was the policy direction of the state at the time of going to
that
court?
point is made. I just wanted
Is it the case that the state thought, well, let's start prosecution, let's save our faces. When we get to a point, then we come to Section 35. Because bear in mind, Heritage Bank, the founders are in court, the same for UT. Is it the case that these Section 35 will be available to these other people, or is only in the case of...
What do you think, as a lawyer, what do you think? Is available or is not?
I don't think, because in the NCA,
as a lawyer,
in the NCA trial, in the NCA trial, we were never offered that opportunity.
Who should offer it?
Both
No, it's not
parties.
both. It's not both. Particularly you, the one who is accused. I have used Section 35 in cases before. You, the one who is representing your client, must go to the attorney general and say, look, the evidence I have seen so far, it doesn't look like things are good for my client, or whatever it is, my client is ready to pay and then pay compensation and be convicted but not go to jail. So if you didn't do that, don't blame somebody for doing it.
The second question I would want to ask in respect of this is that, is it the case that now A1 in the instant case is admitting to saying that, although by documentary evidence, what I admit to is 57, but I plead guilty to the 90 million. Is that the case? Because you see...
Good question. Let me go to the Attorney General then.
No, let me make my point. I'm saying that the state should not paint the impression that by going in accordance with Section 35, we are being saved money. Because from the report, when you look at the terms of settlement which has been presented to the court, we are told that A1 was willing to pay 30 million as at the dates already paid in court, 60 million to be paid in installment. The Deputy Attorney General's argument is that one of the reasons why they've had to go on this tangent is that in time past, when people are convicted, they don't get anything. And he copiously lamented about how it will be difficult to look for the properties of A1 in the instant case. My question is, this 60 million which is supposed to be paid in installment, should the court go ahead and accept that, well, because you have both agreed, I accept the terms. If ASEAN does not pay, does the state know where it can find its properties to offset the 60 million?
Maybe we should go to Section 35 too.
Yes,
what does it say?
I've seen that Section 35.
Yes, what does it say? Because you do that and then you take some risk. Yeah, you are not convicted, but if you don't pay, you end up still going to jail.
Yes, but that's what I'm saying, that the state's argument is that one of the reasons they are going on this tangent is that they don't really want custodial sentence, or it is not in the interest of anybody. And so they will want to go on this tangent and then recover. My point is that if you cannot tell, or there are no specifics that because of the rationale behind the settlement, you bring property number A, B, C, D, or you give us some form of immovable guarantees that if you default to pay, then, I mean, this should be...
You've done the first guarantee, which is 30 million.
Yes, that has been paid. My concern is that...
You haven't, I don't know if you were a lawyer, you would even want your client to pay the money up front. But they have gotten that.
Yes, but
so you should applaud them for that.
It's no guarantee that they'll get the 60 million. But
that is also on the accused. If you don't pay, you go to jail.
Yes, but you see, the point is that...
So in that regard, the law is that it is not the Attorney General's job to now go around looking for you.
Exactly.
You have agreed that you pay 60 million and you pay it within a certain time.
Exactly.
Once you fail and neglect to pay, the law kicks in again. You are put to the court.
Just like when you are fined, if you are not able to pay your fine, you go to... But I'm saying that, so that rationale or that reason by the Attorney General is where I find a bit baffling, because if you are saying that the reason I'm going to this agreement is that I want to save money, now you have no guarantee that the 60 million will be saved, then why? That's the question. There has to be some guarantee for the people.
Thank you very much. But again, when you go to 35, there's no guarantee to be provided. Alfred,
there is no guarantee, let me end with you. Work of the
let me end with you on this. Do you appreciate what Beatrice is saying? That maybe she doesn't understand why you are saying what you're saying, because it does appear that if you get the 30, there's no guarantee that you get the 60 million. Is there not a way you can find and secure the fact that you can actually get the 60 million?
Thank you very much, Samson. I've listened to Beatrice. Yeah, that is the suggestion that she has put up. But let me make this intervention. Per what we have done, as Samson Lardy stated, now 30 million has been paid. If the judge accepts it and says we are going to go by the agreed sum, if the first accused person defaults, automatically we'll go back to court for the court to sentence him to jail. So many that's why we basically say double jeopardy. In that case, we've made some payment, but not this one notwithstanding, you are going in. That's an advantage to the state.
All right.
In terms of providing guarantees, I think it's something I've not met before. Section 35 is not covered, but we are amenable to all suggestions. If it's possible, maybe in the future we'll look at it and see how that one also can be fixed.
What do you say to anybody who may suggest, and I am suggesting this to you, that why didn't you rather require that the settlement be done through the new law, the Criminal and Other Offences Procedure Amendment Act 2022, Act 1079. I'm talking about plea bargaining, where once the person agrees and the terms are filed in court, and on the basis of that, the judgment is rendered, it becomes final and cannot be appealed against. Why didn't you use that rather than 35, where issues can come up and they may take us through another, if you like, call it a Wyoming kind of process. Today in Supreme Court, today the High Court of Appeal, today here and there. But this law, which is fresh, is also applicable and can achieve the same results, and the result cannot be appealed.
Yes, Samson, I think it's also a good suggestion. The Plea Bargaining Act is now in existence, but it is the offer of the accused person that will determine the reaction of the state. If the accused person or the first accused has chosen to go by the Plea Bargaining Act, who have followed him there, but the accused person chose to go by the Cause Act, Section 35. In terms of appealing against the current agreement that we have, if it goes through, I have my doubts if there's a process, unless you can maybe prove fraud. But apart from that one, you cannot appeal against it.
Okay.
It's not appealable, so you just have to stick to it. So something, that one is left to those of you in private practice, whether you want to go by Section 35 or you want to use the Plea Bargaining Act.
All right. So on the 13th, you are going back to the court to... the court says you should come and convince it that this amount is enough.
Yes, that's the ruling of the court. So we're back to the court on the 13th. In all this, I've said that the decision of the judge is supreme. You can agree on everything. Maybe the judge says he is not satisfied. The thing falls, and we have to go back and then have the judgment delivered. So we go to court on the 13th. If the judge is satisfied with the arrangement, we'll move along. If the judge is not satisfied, we will drop it and respectfully ask the court to proceed in accordance with law. Right.
Ghanaians are interested in all the other cases because, as we speak, I didn't cause any trouble yet. Once I'm accessing banking services, I am paying for this bank collapse issues when I didn't cause anything. So, what are you doing to the other cases?
In fact, the state has done a lot of investigations into the collapsed banks, savings and loans, and microfinance institutions. And the dockets, if we were to come to our ministry, you look at how bulky the dockets are. So we are taking them one after the other. I think about a month ago, less than a month, Beige Capital were in court. So it's maybe an announcement to those who manage those institutions. If they think that it is over, it is not over.
All right.
As and when their time comes, we'll get to them.
Yeah, your reference to Beige Capital reminds me. Can you give me a minute on this? He had referred to another case. I think it was done in his own court too, where you did this kind of arrangement. What has become of that?
No, Beige Capital, I think that we've not gotten to that stage, unless maybe it's another matter. We were in court last month for the first time. The court granted him bail. I understand he's not able to meet the bail conditions. He's still in custody. I'll be going back to court this next week I think next week or something. Yeah.
I'm talking about this matter where I think the debt amount was about 40 and you were getting 70 out of it or something, and you reach a similar agreement. I'm forgetting the specific name.
Is it a venture capital?
Exactly,
one?
Exactly.
All right, yes. The venture capital one is somewhere in 2019. There was a similar arrangement for him to refund. That's about 13 point something million. Was it 13? I don't have that. I think 13 or 14 million.
Okay.
But after the state had agreed with the accused person and the state had gone to court with them, the judge, in his wisdom, said he was not comfortable with the arrangement. But rather, the judge gave another suggestion that Mr. Dukun has some property, and that those property, the state should go ahead and auction those property to defray that amount. So those properties, currently as we speak, the auctioneers are working on it. They've taken every step they're supposed to take. And very soon, I think we'll be able to get the money from there. That one, the state never proposed that we're going to take the property to auction. But the judge, in his ruling, said that was what he was going to do. And he did it.
Okay. All right. Thank you very much. I'll have Mr. Otu give us a brief commentary on this, and then we take a break. Section 35, when I said you should look at 35.2, I meant 35.7. It says, where a person convicted under this section defaults in the payment of any money required of the person under this section, or fails to fulfill any condition imposed by the court under subsection 6, any amount outstanding shall become due and payable, and upon failure to make the payment, the court shall proceed to pass a custodial sentence on the accused. And then I was also referring to the Plea Bargaining Act, which has now been done. You know, apart from this section, we passed the Office of Special Prosecutor Act, and we also put plea bargaining there. And then we passed the Narcotics Commission Act. We also put plea bargaining there. And then we felt that we needed one law, you know, to take care of all of that. So we have a new law now that takes care of all of this. So if you have a case from start until judgment has been rendered, you are entitled and are allowed to ask that you want to pay and make restitution or reparation and get a conviction but not go to jail. So you make admission of your guilt. And this one, a part of the section which I was referring to, Afretua Yeboah, says that where a court convicts and sentences an accused person in accordance with the plea agreement, the conviction and the sentence shall be final, and an appeal shall not lie against the judgment of the courts. I thought that would have been a better way. Ms. Otu, what would be your brief commentary on this? Let's leave the lawyers and go to generally what you feel about all of this before we come to you and the government, as in Labour.
Thank you, Samson. It will be brief. I'm not a lawyer, and I haven't followed the case that much, but I've been educated a lot listening to all of you. Thank you for that. The question I ask is, there are many people in jail for having stolen 10 Ghana cedis.
Exactly.
1 Ghana cedis. And it makes me confused. Maybe I need to read more and I need to listen to all of you more. But it really makes me confused. Thank you.
Thank you very much, Dr. Kwabena Nyaku Otu, Chief Economist and Director, Labour Research and Policy Institute, Trades Union Congress. Earlier, you heard Beatrice Annan, who is here in the studio. He's member, Legal and Communications Team, National Democratic Congress. Kofi Bentel is lawyer and Senior Vice President, Imani Africa. We're taking a break, but Kofi wants to say something in a minute. Kofi, do that and let's go on a break.
Well, Samson, you said a bit of it. First thing we need to get right. Look, some of us, you and I, if we were not sure about the process, we would say it. We are saying the process is good. Number two, very important thing is this. In the numbers, what is admitted is just about 26 million, but the state got 90 million. That includes interest and other things. We need to know that. That's also another fact. Then the last one you said, which is very important, is this. The enforcement, what if it doesn't pay? In other arrangements, when you get the person say, I will pay, and therefore they go. If they don't pay, you have to go into a execution, etc., and you may not get the money. In this case, 35 and the other laws related are better because, one, if they don't pay, they will go to jail. All right? Yeah. And also, when they come under this kind of agreement, they don't go and appeal. So you save money, you save stress, you save all kinds of things. All right? So this is far better than what we've had. And I'm adding to it that what has been gotten under this, 26 million having been admitted, the state has managed to get them to commit to pay 90 million. All right. So again, we don't have to go into the details of the figures. The lawyers will do that, but these things must be said.
But Dr. Otu raises an issue. When I wrote about the Plea Bargaining Act and the Community Sentencing Act bill, which doesn't really get passed, so that people who steal plantain and things can also have the opportunity, of instead of going to jail, to do some small service and, get away, so to speak. That is not receiving the needed attention as we expect. But this one has received quick attention. Special Prosecutor Act, we are provided there that you can plead and then pay as compensation and go. Narcotics Control Commission Act, the one we did recently, we are provided there. And we know that these are, quote unquote, your big thieves. What happens to the ordinary person?
On these small claims and these non-custodial sentences, because that's the bulk of the matter. And we need to really focus on them. So there's a lot of work being done there, but people should be clear about this. There's been a lot of thinking across the world. Even murderers are allowed to do plea bargaining because there's a greater good to that. It may not look okay in the beginning. It may not rub you right at the beginning, but sometimes you have to trust the people in charge. I doubt if any of the people complaining now, if they were put in the facts of this matter and given the details at this stand, I doubt if they'll do better than the Aegis Department has.
Okay, thank you very much. But because you mentioned murder, let me state that in our law, if you commit treason or high treason, you can plea bargain. If you commit high crime or accused of high crime, rape, defilement, genocide, robbery, kidnapping, murder, attempted murder, abduction, piracy, hijacking, and an offense relating to public elections, you can't plea bargain. We'll be right back. You're welcome back. This is Newsfile. It's your most authoritative news analysis platform. And here on Newsfile, as always, we put Ghana first. And just a couple of the messages that you've sent in on the first issue before we go to labor and the questions of bread and butter. There are tons of messages that you are there. It's in commendation that we have given some education. Thank you for that. So I'll read the others. Sam SKN says he needs to pay back the full amount and serve jail term, else that will create a loophole for others who want to do same. Steal big and pay less shouldn't be the modus operandi. Okay, so you sent this before you got to know the facts about the money outstanding. Opoku Somwa says the judge is spot on. Which business-minded government will go for a refund of about 90 million in 2022? The city has depreciated more than 100% since the collapse of the banks. The interest should be done cumulatively. Okay, so this also definitely was sent before you got to know the figures. Masaudu Jr. says, for me, anything that will bring back lost money back, I am in support of it. Uncle Rokus says he must pay all the money and still serve not less than 5 years in jail. Okay, so it depends on what law you use. But the law that they are invoking now, if the court accepts it, no jail. Conviction will happen, but no jail. Ayayi Precious says the court's decision is the best. That's the way to go. And there are many of you who are celebrating Justice Eric Che Bafor. Well, that court is known, and the lawyers know that court. He's a no-nonsense judge, and he doesn't allow anybody to waste his time. Kweku Whetstone says the judge is a national hero for putting the interests of Ghana first. The fact that the AG thought a settlement of 90 million is the best is scandalous, to say the least. I'm sure you also sent this before you got to know the facts of the money itself. Well, the AG says whatever his support is tendering is for the court to accept or not accept. It's one way or the other. Mr. Obeng says some people are in jail just because of 500 CDs. Yes, that's why some of us are pushing for the non-custodial sentence regime to be passed quickly as possible. Dominic Obing says it won't be in anyone's interest to keep him in jail to be looked after by the state. Better to strike a deal with him and recoup a significant part of the money. We need to cut our losses. There is a reason why most rich people hardly go to jail. Kwame Esiedu Sapong says, I think this section 35 in our law must also allow stealers of one plantain to pay with 10 plantains and stay out of jail, or at the end of the day, they will be convicted and would have provided restitution too. Absolutely agree with you. And that's why I will invite all of you to join, groups like the Commonwealth Human Rights Initiative, who are campaigning strongly for the community sentencing bill to be activated into an act. CDD and the rest of them started pursuing it sometime in 2007, and it is still on the books. But the Attorney General says they have picked it again, dusted it, and they are seeking to improve it. Let's have that one too. Thank you very much. Now, let's get to our second matter, which has to do with labor, organized labor rejecting 18%. That's been offered by the government as far as their base pay is concerned. We have Ben Arthur, Chief Executive, Fair Wages and Salaries Commission, joining Dr. Kwabena Nyarko Otu, Chief Economist and Director, Labor Research and Policy Institute, Trades Union Congress, Mr. Kofi Bentil, lawyer and Senior Vice President, Imani Africa, and then Beatrice Annan, Member Legal Communications Team, the NDC, to discuss this matter. And of course, it's interesting to find that Beatrice also has an article that supports the community sentencing. She is outrightly against the custodial sentencing. Some of us, we think it should be there for some of the, the very sinful things that go on. Thank you. Now, some are surprised. Yes, some are surprised that the negotiations that have been going on so far for improved pay don't seem to be making any headway. There is 18% offered by the government, and the organized labor is not accepting it. They are asking for 60%, and even that, they said after the budget was read, there's an increment in VAT, you know that? And because of that, certain things have changed. So now they will take 65%, not 18%, not even the original 60%. We have a fresh letter. This was done as recent as 29th of November, 2022 by the University Teachers Association of Ghana. They are supporting what is going on and asking for a number of things. I will also show you what they are also saying, that the next academic year may also see them, going on some actions if government does not respect certain things. And they also want government to not freeze public sector employment completely, but to make room, particularly for universities, because they were not allowed to employ previously, and numbers are increasing, so lecturer-student ratio must improve. Let's listen to these clips at the end of the negotiations, what Closer had to say, the Deputy Minister for Employment and Labor, what he had to say, and what the Deputy General Secretary of the TUC had to say.
And government says they are going to consult. We also stated that we're going to meet our constituents and then we also give them feedback. So this is how we ended. We are not being unfair. As you are aware, we've read the budget, and there's an indication that there will be an increase in VAT of 2.5. And then also it has been indicated that the tax brackets are going to change. So this is fresh information that we've brought on the table, because the budget has indicated certain issues relating to VAT and the tax bracket that is going to increase our burden. And so we need to compensate for that.
We have had to table something anytime we have met. But Labour insists on a figure. So we are going back and we'll reconvene. I am disturbed. I am disturbed. But in the spirit of negotiation, we will go back and come again. Space. It's about money. It's about ability to pay. So I am also worried that they are also not moving to come and meet us at where we can come to a compromise. Because for the fourth consecutive times, we have had to table something. And Labour says that they are unwilling to take it. So it's a clear case of frustration, very genuine one indeed. So it is not like I am not happy. Of course, you don't want me to be happy when there is this state of affairs. Well, we are going back to look at what we can do, and then if we can go further, we will let the media know.
I don't agree with you that it will be difficult. We've never been difficult. We've been considerate for years, and many things have gone wrong. So I think that is the time to right the wrongs. The single pay salary structure is the most indecent structure in this very country. And we think that this is the opportunity time for us to right the wrongs. So we have not been difficult. We are the same union leaders. We are the same people that took the 4% and 7%. We are the same people who are asking for 60%, and the reasons are written clearly on the wall. You will never take anything below the 60%. We are not representing ourselves. We are representing our constituents. And we have to go back and inform our members who sent us to negotiate for them.
Right. So you heard the Deputy Employment Minister, Bright Rekubrobe, frustrated about the developments, and you heard, Labour leaders insisting they're standing their ground. Nothing's to change. They want 65% raise. Dr. Nyakotu, the question that many are asking is that you appear to be acting as if you are oblivious of the developments across the world, and particularly Ghana's case, which is actually worse. Hello, Doc.
Samson, we are not oblivious. We are fully aware of what's happening in this country and across the world. We are fully aware that our members staying in Kaswa have had to endure much higher increases in trotro fares from Kaswa to the ministries. We are fully aware that because of increases in cement prices, rent have gone up for our members. We are fully aware that school fees have gone up for private schools, and we are fully aware that today it costs more to put food on the table for yourself and your children. But you see, the problem is that many people talking about wages, the economy, don't talk about these household issues. We talk about the budget deficit that has been presented. We talk about the revenues that are not meeting expenditure, the national level deficit. But also a household deficit. What households require, workers require to be able to have basic living for themselves and their family. What they require compared to their earnings is woefully inadequate. And that deficit, nobody talks about it. In fact, it is more serious. It is more serious a deficit than the government deficit that you find in the budget. So we are not oblivious at all. We know what our members are going through. And we know, as the Deputy Secretary General said, it is about time we correct the wrongs of the past. And what we are simply saying is that just make sure that the massive declines in earnings actually stop. We don't want those massive declines to continue in 2023. That's all that we are asking for.
Yes, but the circumstances are such that you can only ask for so much, are they not? I don't know. Elsewhere you see strikes going on, and they are asking that their wages be pegged to the inflation. In the UK, they have announced various strikes, particularly those who are in charge of the rail, and the rail system is sort of the backbone of the transportation system in the UK, and they have announced and they have staggered how they want the strikes to go on. But the government, if you follow the discussion, is clear about it, that we are in this together. There has to be some burden sharing, and we can only offer so much. So at this time, we can't actually give you anything.
So in 2021, we shared a bigger part of the burden, 4%. 2022, 7%. And our members can no longer reproduce themselves. And I mean, it is important to know that if you say in the UK they have pegged their expectations at inflation level, I'm sure you know the inflation level in Ghana today. It is 40.4% compared to the 18% government is offering. But Samson, it is also important to put the labor proposals in proper perspective.
All right.
See, the single span salary structure, there's what we call the base pay, the minimum pay. The agreement we had with government, and this is not supposed to even be an agreement, it's supposed to be common sense. When single spine began in 2010, we said that they should never go below the minimum wage. Today, the minimum is 14 Ghana cedis, 88 pesos per day. But the base pay on the single spine salary structure is 11.33 pesos. So it means that the base pay is lower than the minimum wage. We are asking government to put it at least at par with the minimum wage, so that we don't get to pay anybody below the minimum wage, which, as you know, is not proper, it's not legal. And then we are also asking that in 2010, the base pay was 10% above the minimum wage. So just add that 10%. And that takes you to about 44%. But you also know that we recently secured a COLA of 15%.
Right.
What I'm asking is that keep that COLA. So when you add that COLA to the 44, you get something like 59, and then we round it up to 60%. But Samson, that is not all. On the base pay, there are what we call pay points. So between the very base pay and the next one, there's a percentage difference. That percentage difference is about 1.7%. When we started the single span salary structure, the idea was that we will push from 1.7% to 2% at some point. We are 12 years into the single span, no movement has been done. So again, we are asking that we should push it from 1.7% to 2%. Now, Samson, when you do all of these things together, we are asking for something in excess of 100%. That is if you pushed from the 1.7% to 2%. So what government needs to do, instead of coming with 18%, 15%, what is government's take on all of these components or the proposal that has been presented by organized labor? Because there are various components, they just add up to something. What is government's take on the 1.7% going to 2%? What is government take on keeping the 15% COLA? What is government take on moving the base pay from its current level to the minimum wage level? The reason why labor is not moving is that government is not saying anything about distance. All that is saying is that, okay, we offer 12%, we offer 15%, we offer 18%. But you see, our objective in this negotiation is simply to stop the massive declines in real incomes. And the figures are there. Take SASCA service expenditure data. And you see the basic amount people have to spend on transportation, on food, on healthcare, on education, and compare that to the average pay on the single span. You see that households, workers have much bigger deficit than the government deficit. That is always the front line, in the front lines of the newspapers and on radio stations.
Kofi, I bring you in before we have fair wages, or Beatrice will speak before fair wages. Sometimes fair wages, that's a bit of a mediation role in the system. We don't know now whether they themselves have fair wages to be able to mediate, because the system is something else. And we will show you some graphics very soon, doing a comparative analysis of salaries of Article 71 holders and public sector. You're looking at the average Article 71 office holder, how much they are getting, and you know the average, the least earner, Article 71, the least earner, as at I think 2016 was 11,661 Ghana cedis. If you are on the single spine, then the least earner is getting 178 cedis, a difference of 11,483 cedis. This is absolutely unconscionable. How do we get to rationalize all of these? And sometimes Dr. Nyakuo too and the rest of them, they talk, we hear them, you can clearly see their pain, and yet the response that must come doesn't seem to come. Yesterday, Kofi, I was listening to the Super Morning Show where young, girls and one boy were put on the show. They were talking about how to help their parents in these difficult times. And you could tell how they appreciate what is going on. And one of them almost got me to tears because she felt their parents can still help them somewhat, but there are people who just can't get a meal a day to eat. And just because of that, she was overwhelmed and she was weeping. How to assist such people? How do you explain that the least earner for an Article 71 holder is 11,661, and the least earner on the single spine salary structure is 178 cedis? What do you do with that when Kenke is sold at 5 cedis? Yes, Kofi?
Right, Samson. So we have had a long history in Mani of commenting on salaries, civil service, productivity, etc. And for the record, if you go back, you will note that we complained, we gave reasons, we wrote papers on why Fair Wages Commission will not succeed. As we speak, they have failed. Sorry, we can analyze that and we can prove that. I'm saying this to a point. Number two, we wrote a lot and complained a lot and analyzed a lot and debated a lot about why single spine, what we call S4, was not going to succeed, was going to dump a lot of cost on us, but was not going to increase productivity. Over the years, what we predicted has happened. The point is this: we have been failing at dealing with public sector wages in this country over time. But I have news. Part of the problem has been productivity, the productivity of the people in the civil and public services, which we've all complained about. The news I have is that all the analysis we are doing now, everything we are seeing now, and I'm saying here now, is that zero of the problem is with the public and civil servants. All the problems are with the leaders. Let me explain. Simple economics. If you are an employer, you know this. When you employ somebody, the person's wages is not a net loss to you because the person helps you to make more money than you pay them. So if you take the civil and public servants, the government workers, whatever we are paying them, if they were producing well enough, will not be a net loss. It won't be a problem. It will be a fraction of what they are making. So why do we have a problem? We do have a problem because, one, the politicians, even in private sector, it comes down to leadership. It comes down to what managers and leaders do to make sure that you get the best out of your workers. And leadership in this context is the politicians and our leaders. It is very clear to us over the years that the lack of productivity in the civil and public service is not because of lack of capacity. Indeed, we've looked at the private sector and looked at the public sector. The public sector has about 3 times more qualifications than the private sector. And whenever they move, whether to international organizations or into the private sector, they produce massively. So why don't they get the same levels of productivity when they are in the civil and public services? It's because of the leadership and the political messing up of that space. It's because people are appointing political misfits into office. It is because you have square, pegs in round holes. It is simply because the leadership there is poor at every level. To that extent, we should not be blaming the public sector workers for the lack of productivity. In fact, we've said something else as part of this discussion, that what we need to do is what we call competitor parity. Look, if you take the Auditor General's Department, the auditors there are as competent as the ones in KPMG. All right? If you let them work, they'll work. So there are ways to go about it. That is not why we are here. So I'm not going to go through it. So let me make this point. I believe later on we can expand it. I am fully in support of everything that labor is demanding.
Even at this time, 65%
yes,
at this time.
Yes, and I'll explain to you why.
We are at IMF, we are begging. Without that, we are doomed.
Let me finish my point. You are talking about inflation. You are talking about devaluation of the currency working together. Their wages have been where they are. And you are talking about a situation where they are not able to even make enough on the side of whatever it is. So, given inflation, given devaluation, which is directly because of actions, omissions of government, they have a right to demand it. Then this is the last point, and I made this point on the Super Morning Show. You have a situation in Article 71, where the people who are elected and people appointed to serve us, to be the people to lead this nation to prosperity, are raping us. They have become predatory. They have a separate set of rules for themselves. You just read the minimum wage under Article 71. I know stories of people whose cars were 4 years old. How bad is a 4-year-old Land Cruiser? And then they have a new set, of allocations. And one of them was saying, oh, they bought their 4x4. Now they have enough money to buy a Fortuner. They are not sure what to do. They are raping the nation. As long as Article 71, and let me make a point. In Article 71, the Constitution does not say this is it and you have to take it by force. It says that your salaries and wages and also perquisites shall be determined by a committee. What it means is that some people will sit down, look at the conditions around, look at the things going on in the country, and decide that this is what is right for you. Whenever they sit down to determine, they go up. And now they are paying themselves astronomical sums of money. And if you take the situation of the Council of State, people are feeling ashamed to take the money they are being given. And they are not doing any necessary work over there. So as long as the leaders who are negotiating with these labor people are paying themselves all those crazy sums of money, riding in 5.7 liter vehicles all around, when they can't afford it personally, some of them, they should continue to demand it. And we have another set of Article 71 plus, what we call them. They are not even in Article 71. They are political appointees and attachments. And they have now arrogated to themselves Article 71 pay. So you have a situation where less than 1 million people are just leasing the country up.
You're talking about the guys at the presidency, which list keeps bloating.
Yes, they are one of those groups. Article 71 plus are people who don't belong in Article 71. It's the principle I'm talking about. You have the political elite, people who have the power, just getting into our resources and spending it. And then you tell labor not to ask for what is inflation, what is devaluation in our currency. They are having to deal with situations. And when you want to solve a problem of food prices, you bring a few truckloads of plantain to the ministries and you think you solve the problem.
Okay.
Look, Samson, our leaders have the solution. If they want to reform the civil and public services, they should reform it for productivity. Then their salaries will not be a net negative. If they pay them well, they will still work more. Until then, labor should continue to insist on what they are demanding. It is fair.
Bitri, let's say Bitri Sanan is an aspiring Article 71 office holder. What do you make of the analysis that we put on the screen? The highest Article 71 earner, we're talking 2016, is about 30,000 cedis.
Wow.
And the highest single spine earner is 4,300.
Yeah.
That's incorrect. And then the average, 18,000 for Article 71. The average for single spine is 1,128 cedis. And then I spoke about the lists, where the least Article 71 is 11,661. And then the least for single spine is 178. This is 2020 Emoluments Committee. The source is what we are referring to. So if you want to challenge it, that's where you go. Yes. What do you say about this and what Labour is insisting on?
Something. I think that the point has to be made that Labour is right. Labour actually constitutes the very microcosm of the bigger economy. And so it is not the case that the macroeconomic indicators of the country is just depleting away and Labour's life will be better. I think that point has to be made. And so if the economy is not doing well, it's obvious households are not doing well. And Labour is a very important arm of every nation when we want to develop. Now, it is important to state that in determining the salaries and wages of Labour, it should and it ought to be pegged with inflation. And in our country, the steep depreciation of the cedi and the standard of living. I have heard government communicators and people in the Labour space who are pro-employer say that we have to look at both sides, that the government does not have money to pay what Labour is demanding. I think that
is fact.
I don't think so, because you see, the optics do not support this. I cannot assume that that will be factual. When you look at how government officials are going about their daily lives, and even if you look at the 2023 budget, and I'll come there, you cannot tell Labour that the least of you should be earning 178 cedis when you have government officials flying to Qatar to watch the football match at the expense of Labour. And so Labour will say that, oh, if there is any jet to fly, we also want to be in a position to go to Qatar and watch the football match. Because sometimes the data is as important as the optics. Now, if you look at the government of Ghana allocation for 2023 in the budget, the government has earmarked to pay 44.99 billion as compensation.
Yes.
And then when it comes to interest payments, the government is doing 52.55. What it means is that this government has recklessly managed the economy so much that the monies which go into payment of interest is more than what it is allotting or has allocated for Labour, at a time when we are being told that inflation is 40.4%. And so if, from the data you showed on the screen, if anybody in the public sector was earning 4,324, which is supposed to be the highest of the earning, if you do a 40.4% depreciation of that amount, technically the person is going home with just about 3,000 or less. And so they would demand that. But one would have thought that governments will make all these, or governments will make the situation such that many would empathize and say that Labour, hold your breath, but it's not doing so. This is a government that is telling us that we are so broke, and as a result, I have to increase VAT from 12.5% to 15%. And it is going to have a cascading effect. And so if you look at a 21% increase, Labour will be part of those who are buying these goods and services. And so given the depreciation of 40.4, they cannot add an additional 21% to it at the same interest. So that's why they're asking for 65.
And remember what has happened to e-levy too.
So I'll come there. And if you look at, despite all these, one would have thought that the government will say, oh, I'm bringing some austere measures so that Labour and ourselves can share. The government has increased its expenditure by 51%. In the 2020 budget, the government budgeted to spend 137 billion. In the 2023 budget, as we speak, the government is spending 205 billion. So if you have increased government expenditure by 51%, without showing where those increases will go or how they will impact on Labour directly, which is supposed to be one of the arms of taking chunk of government expenditure, then Labour will be asking all these questions, because on the part of government, there is no prudence. one would say that the government has come out to announce some austere measures to show that, oh, Labour, you are not in this alone. But Samson, those measures were announced as far back as this year, March. And there were no implementations. Those measures have been repeated. So it becomes difficult to even tell Labour that to hold on, because the government, which is the employer, is not showing any sign that we cannot afford the 65%, except to say that, you know what, we can afford an inflated budget, we can afford an increase in our expenditure, but we just cannot afford to bring Labour in. And you don't expect anybody to accept that. And like Dr. Kwabena said, when we are talking about the cost of living, it is not just the cost of living, but the standard of living in the average Ghanaian lives have practically reduced. Something I know lawyers who don't drive to court any longer. These days, they are doing carpooling in the firms. These are supposed to be people in society who are privileged. I know medical doctors who are no longer driving. So you can imagine what the ordinary person who is not even a professional or the teeming unemployed people are going through.
Somebody has been drawing my attention to the reduced traffic in town.
Reduced traffic in town.
I've experienced it
myself.
Yes.
And I know families who have now drawn a meal table that we eat breakfast at 10 and we eat lunch at 2:33, so that it's like an intermittent fasting. These are people who are employed in the public sector. So consistently, the communication cannot be that Labour should suffer against the background that the government is unable to manage the cedi or our currency. The government is unable to manage its expenditure, and expect that every time we call Labour to fasten its belt, while the government loosens its stomach and consume more. It is just unfair, and I will support the call by Labour to hold government responsible. Because you see something, the point also has to be made that it is unconscionable that at a time when we are all agreeing that if you look at the space, one of the least paid people or some of the least paid people are in the public sector. You have a government that is bent on spending so much in building a national cathedral. As we speak, we are being told by the Auditor General's report that 142 million cedis have been spent. In the 2023 budget, they've earmarked to spend 80 million. So when you add all these other ancillary...
The budget has even projected for the cathedral beyond the...
Beyond 2023.
25 or so.
Yes,
so,
they've proceeded.
I don't know why. Is that done in a budget? When you know your life terminates 2024, and then you project a budget far beyond your...
Yes, normally they have a 20 or a 5-year or 4-year projections so that it can guide their planning. But that should tell Labour that with this government in power, there is no future for Labour, because if you look at its other allocation, government says that other expenditure which we cannot tell what they are, the government is spending has increased that expenditure from 8.34 to 26.74, moving an expenditure from 8.634 to 26.74 at a time when you have these very fundamental issues to address. And every budget is supposed to be the economic policy of the government. And in addressing that economic policy, you cannot do so without addressing Labour. So you can't keep telling us, or the government cannot have a shifting tongue and keep saying that, you know what, let's all fasten our belt, let's all engage in some measures to save the country. And then government does not show that it is committed to doing something. Young people are suffering, and if you look at the unemployment rate, which is 13.6 as we speak, and the fact that there is going to be an employment freeze, not even a net, all young people do not have an opportunity of being part of the public sector. What one would have expected is that for those already there, you would even make their lives better and not worse. Right. So you cannot mismanage the fundamentals. And when Labour complain about the fundamental, you say you have an issue with it.
Let me hear from Dr. Benata, Chief Executive of the Fair Wages Commission, and then we'll take a quick break and return for our final, comment. Now, I remember when I was showing the slides, you were disagreeing on the amount, and the highest amount I referred to for Article 71 was just about 30,000. I appreciate where you may be coming from. The fact being that what the Emoluments Committee, as it were, proposed is not what the executive stuck to. So it's actually higher than this. As we know, the figures are far higher than what we have used for the analysis. But some would ask.
But Samson, let me help you with the figures.
Yes.
So in 2016, the Emolument Committee proposed 22,000 Ghana cedis for the president.
Right.
It was eventually increased to 29,000, the figure you have there.
That's right.
That figure. In 2020, the figure 30,000 now goes to about 47,000.
Right.
But you should compare that with the figure on the single spine, which the minimum figure on the single spine today is about 414 Ghana cedis, and not the 178.
Okay, 414. Thank you very much. So and I'm just going to refer to, this is an extract from the executive summary of the report of the Professor Yaya Ntamu Abedu Presidential Committee on Emoluments for Article 71 office holders, June 2020. The committee strongly urges the government to also spare no effort at reducing the wide gap between the highest and the lowest paid public servants in the country. The goal must be that the salary earned by every worker should enable him or her to live in dignity, as the Constitution says. Why are we still here?
Anyway, thank you very much. Let me take this opportunity to greet our viewers. You may have to give me some ample time.
Sure.
Because
we'll take a quick break and come back.
For interventions.
Yes, once you do, once you speak for about 5 minutes, we'll take a quick break.
Oh, 5 minutes.
5 minutes is a lot of time on prime time.
Let me proceed from where my sister left off. I will be addressing some of the issues as we move along. In the first place, organized labor has future with government, simply because the crisis that we face is not just unique to Ghana. We can go into the details and its theories, but this is a government that during the COVID-19 pandemic, many nations laid off workers. There was not a single public sector worker who lost his or her job. It came at a cost. So when you say on air that organized labor do not have a future with this government, that is not supported by the fact. We alluded to the point where my sister also mentioned that, of course, once we have unemployment rates going up in this country, and there's a freeze on employment proposed by the budget, is going to lead into dire, consequences. If you also care to know, to get same from the budget, it's the same budget that talks about Youth Start program, which is a program that is going to give the youth, ample opportunities to be entrepreneurs. And I've already stated on several platforms that Ghana's structure of economy by way of employment sections or sectors is such that we have over 85% of all employed persons in Ghana being self-accounting as self-account workers with employees or just one person working. So if we want to really open up the opportunities in this country for people to be hired, the best approach is entrepreneurship. We have the Job and Skills Project that is also giving opportunities. In fact, across the globe, there is no single government that, by way of proportion, that is increasing its portion of employment. Worldwide, the government's ability, by way of percentages to hire people, is going down. So the way forward is to ensure that we get graduates to get into entrepreneurship, develop the ability to hire their own colleagues, and we'll move forward from there. And it is contained in the same budget. I may not want to go into details in debating the budget because that's not what I'm here for. Dr. Kofi Bentil, the lawyer, stated that fair wages has failed. I beg to differ. The single spine salary pay policy is the single pay policy that has lasted the longest in the history of Ghana. We have had several pay policies that, have seen operations as far as regimes are concerned. We've had the goods, we have had other ones, we have had the price and incomes, but that eventually gave way to the Fair Wages and Salaries Commission. If you look at the single span pay policy, government admits, and by so doing, we are even, there is a committee that is formed under the National Tripartite Committee to get it reviewed. So we admit that there are some areas that needs review, and we have far advanced as far as the review process is concerned in terms of the reporting, so that it could go to cabinet or get organized labor engaged. It becomes a policy for implementation. So we admit that there are certain aspects of the single span pay policy that ought to be reviewed, and it's currently being done. But that is not to say that the Fair Wages, and Salaries Commission has failed. It is not supported.
I ask a direct question. Are you supervising or ensuring that this is done as the Yaintia Bedu presidential commission said?
I'm coming.
You need to reduce the gap. It's too wide between the highest and the lowest paid public
you may have
servants
to
in
be
the
very
country.
patient.
People are receiving what we can clearly say that reduces them to less human.
I'm coming to that. The issue with productivity in the public sector and the civil service, if I should say public sector to engulf all of them, of course, I agree with Kofi Bentil on that. And it is not as if we are not doing anything. Currently, we are collaborating with MDPI, NDPC. We are collaborating with Public Services Commission to make sure that the performance management system in the public service is reviewed in such a way that we'll be able to link pay to productivity. So that is very key. But fair wages does not determine Article 71 office holders' pay. And for your information, we do not determine that. There is a different mechanism for determining that. And if we really want to vary it, the way forward is to support a constitutional review, so that at the end of the day,
why are we blaming it on the Constitution?
No, I'm saying that the way forward.
The Constitution doesn't say pay yourselves 40 something, almost 50,000 a month. The Constitution doesn't say those who are heads of the state-owned enterprises, some of them should be earning over 80,000 a month and getting a DSTV allowance, getting a lens allowance for the lenses they wear. The Constitution doesn't say that.
Samson, what I'm trying to arrive at is to tell us that when it comes to fair wages, I'll come to the other issues that you have raised. When it comes to fair wages, we don't have jurisdiction in that area at all.
You should be advocating.
So coming back to the comparison, oftentimes I have heard these arguments over and over again. Article 71 office holders pay per the wage bill is not up to 0.1%. That is not to say that the disparities that you are, displaying on air now does not exist.
Okay.
That's not to say that.
Thanks for.
But I just want you to know that the mechanisms for even evaluating the jobs of Article 71 office holders within themselves is very different. For example, if you go to Parliament, how are you going to evaluate the work of parliamentarians through the way we do at fair wages? You have PhD holders who are first-time MPs. You might have a secondary school leaver who might be an MP. You have people who have been MPs for, say, 4, 3, 5 terms. You have somebody who has just arrived. How are you going to do that?
The Constitution says equal pay for equal work.
Of course.
We'll take a break here and return shortly. We'll be right back. You're welcome back. This is Newsfile. It's your most authoritative news analysis platform. And here on Newsfile, we put Ghana first. My guest discussing organized labor's rejection of government's 18% as far as the base pay is concerned. Beatrice Annan, member legal and communications team, National Democratic Congress. Dr. Kwabena Nyako is Chief Economist and Director, Labor Research and Policy Institute of the TUC. We also have Ben Arthur, who is Chief Executive, Fair Wages and Salaries Commission, who was speaking before we went on the break. Kofi Bentil, lawyer and Senior Vice President, Imani Africa, is also on. Clearly, I'm happy about the way there's a lack of leadership in some of these matters. And if you have heard him in the course of the week, together with the CDD's Kojo Asante, they are very unhappy. At the moment, we have Professor Stephen Adair joining the discussion about government showing that it appreciates what is going on. The president is not cutting down, downsizing. People like Professor Adair suggest he can downsize to up to about 40 ministers, and he's not doing it. He doesn't seem to want to listen to anybody about these things. They say V8s, there's a certain suspension on some of them. We don't know how exactly all of that is going to happen. So people are really unhappy. While taxes are being increased, those who are supposed to show that we are in austere moments don't appear to be doing that. And yet they are taking money from us to fund that kind of life, which people are very unhappy about. The budget was read, and the budget discussion, debate in Parliament, MPs from the NPP or government side are in Qatar and watching football. The president also flew out, and people say, Kojo Pumpuni Asante says, this is an insult. He feels insulted that he's paying tax and the people he's paying the tax to don't respect him in the manner that they conduct themselves. Right. So you were making that point that maybe the comparison may not be the best, but the expectation in the public is that you should be able to play some role, to bring down the unconscionable, salary regime and the gap too wide between the 71 people who are leaders and the public servants.
I alluded to the fact that for us to be able to go that far, of course, there are two separate regimes for the determination. So definitely we will need mandate to do that. And I do not throw away the suggestion that we should be up and doing about it. So I take that advice accordingly. But going forward, I take this opportunity to plead with organized labor. Government position is not to say that they are not deserving of what they are asking.
Okay.
And we have been very consistent with that.
Okay.
We have never stated anywhere for anybody to carry on as a vote to say that government is insensitive and that fair wages and the bodies that lead the negotiation do not understand the plight of organized labor. We do. In fact, you must also admit that we are all workers. The president is a worker, myself, I'm a worker, my sector minister is a worker. But you see, there's one thing that we must...
But don't use those as examples, because everything they have is paid for.
I'm only telling you that we are all workers in this country. And that what organized labor faces as a challenge is not in isolation. Government equally faces a similar challenge. So the way forward that we have been asking...
But obviously those are the top. Don't feel it as, other people who are earning
you may have to allow me
400 that we are talking about.
You may have to allow me to make progress. So we all agree. But you see, we live in a country where we have about 50% of our tax revenue going into compensation. Whatever your mathematics and proportions might be, going into compensation. We need to be worried a bit, because what happens to, say, goods and services? If we're going to pay so much on compensation in such a way that you will not be able to make available goods and services for the same workers to use, precisely, you are not going to be able to give materials or provide materials for work, which is the obligation of the employer. If you are not going to be able to give equipment or provide equipment and satisfactory work environment for the same employees, what it means is that yes, you will be paying the wages, but you are not going to get the people productive. Okay. And I can tell you that it has its own implications.
Right. Dr. Kwabena Yakwotu, we have just about 2 minutes to get out of the studio. Having listened to him, and I'm also concerned about why is it that from your end too, you are not pushing this recommendation to get, things change about the emoluments?
We have pushed for this in any one of our submissions. We have said it. And you see, the effect of this differential is that there's no way you can get people on the single spine to kind of agree with government, when in fact, when it comes to your own pay, you have money to pay. And Samson, let me tell you that the minimum pay on Article 71 is about 17,000 now. And I'm not going to mention institutions. These are institutions where, if you check the Constitution, they are supposed to, the commissioners or whatever, they are supposed to actually meet 6 times in a year. And they take 7,000 Ghana cedis a month. The civil servants there, working from Monday to Friday for 27 days, actually take about 2,000 Ghana cedis. These kinds of differences have to be bridged. And you are right, Samson, when you say that the Constitution doesn't tell us how much you should pay anybody. The first Article 71 committee actually put Article 71 office holders on the existing salary structure at the time. I mean, the way forward from now is to, if the government really thinks that times are hard, is to bring all the ministers onto single span. Bring everybody, all the appointees onto the single span. But on question of productivity, let me say that something. There are challenges there, and there are challenges with political leadership for the civil service and everything. But workers in this country are doing their best for Ghana. Take the police. In spite of all the problems, Ghana is relatively peaceful. Crime rates are down. It is because the police are doing their work. In spite of all the challenges, the nurses and the doctors are keeping this nation healthy. Other people from other countries are coming.
All right.
It's an indication. We are doing something. And you cannot say that this country is so less productive.
I'm sorry, but we have run out of time. But because this is a continuing discussion between organized labor and the government, I'm sure we will return to this in our next edition of the show, and so spend sufficient time to try and exhaust this issue. My outfit, as always, is by Habil Couture. You can find them at Ajiringano Gate, East Legon, and you call them on 0200 84 1988. My guests have been Ben Arthur, Chief Executive, Fair Wages and Salaries Commission, Dr. Kwabena Yakwotu, Chief Economist and Director, Labor Research and Policy Institute, TUC. Kofi Bentel is lawyer and Senior Vice President, Imani Africa. Beatrice Annan, Member Legal and Communications Team of the NDC. I'm Samson Lardy Anyenini. Thank you for your company. Have a good afternoon.